Adams County depends on WDXE News. On the air since 1951. This is the legend. 105.3, 95.3, WDXE.
Yes, indeed. It's time for Stan Pierchoski and Bulletproof Estate Planning. It's Friday, man.
Good morning, Jeff. It is Friday.
Yeah, we made it all the way back around to Friday. And Stan, have you had a good week?
Yeah, I had a good week. It was very busy, but it was good.
Yeah.
It's one of those days that seemed like every day of every hour something was scheduled for me to do, or
yeah,
that kind of thing. So I'm very busy, but
is your headphones messed up a little bit?
it seems more. Let me see. I got to follow the wire and get in there. There we are.
There you go. You may have to adjust your volume there a little bit.
Is that the right? Well, that's the wrong way. That's too tight. Okay, yeah, that's good.
That good?
You can still hear me, right?
Yeah.
Oh yeah, good.
Yeah, yeah.
Um,
Those headphones have a volume, but your mic is good.
My wife says I'm losing my hearing. I'm not ready to accept that yet. Sounds like Mean Joe.
Yeah, Mean Joe turns them up really
he's
loud.
Just as bad, so I get it.
He turns them up really loud. So there you
And I
go.
heard you talking before the show on the way in that talking about nicknames.
Oh yeah,
And
yeah.
I guess I had a nickname. My name is Stanley, and in Polish it's kind of pronounced Stanislaus.
Stanislaus.
I mean, I never really went by that, but I had a grandmother who used to call me Stush, which is short for Stanislaus. And I sort of grew up as a kid, and my family, everybody called me Stash, S-T-A-S-H, Stash. So
that's a good nickname.
Yeah. So I had that for many, many years. I mean, I think my siblings, when I talk to them, they still call me that. So,
That's a good nickname.
Yeah, but it was founded in something. You just don't make it up and call somebody mean like you do.
Well, my little grandson, who's now 2, he is beginning to be called the Tick.
Oh, no.
So anyway, we've kind of hung him with that. So he's the Tick.
Well, today is my wedding anniversary.
Oh, it is. Well, happy anniversary.
August 29th. 38 years.
38 years. Well,
It probably would be more, but I got married a little late. I was like 31 when I got married. So
yeah.
For most people who get married around 21, would be 48, but it's 38 good years. I'm kind of struggling for. I mean, we do, instead of buying gifts for each other, what we've done for many years for things like anniversary and Valentine's Day is we think of something that we need. Like, I don't know, you don't buy your wife a new washing machine. I mean, it's just, what I mean? That's not my idea of a gift.
That's not a great
gift. If you need a new
gift.
washing machine, you get one. Well, stuff like, I don't know, maybe a couple of anniversaries ago, we thought we wanted to get some different living room, new sofa, and a couple of the recliners that go with it and stuff like that. And we bought this. We bought that collectively. Kind of like not surprise gifts that you wrap and give each other, and not even necessarily on the day. Just we decided to do that on the day and then we went and bought it. And we've done stuff like that. We have not been able to come up with anything this year. I was talking to her yesterday and this morning, so I just can't think of anything that we can do that with. So I probably have to go get something.
You may have to get something.
And after 38 years, let me ask you to experience this. I don't mind buying my wife a gift. As a matter of fact, I enjoy it, but I really do struggle on what to get because. Here's what she says about me, and I think the same. She says, she gets mad at me if I need something. I don't know. I'm kind of on the weekend, I fix things. I like to have good tools.
Yeah.
And if I need something, if I'm doing something, I need a tool, I just go to Home Depot or Harbor Freight and get it.
Go get it, yeah.
And she says, man, you wreck a good gift idea when you do that. It's like, but I need it. I need it now. I don't want to wait till the next event that comes up. So, that when she wants to buy for me, she says I'm very hard to buy for, and I feel the same about her because, people say, oh yeah, jewelry's always fine, but she had told me, I got plenty. Don't do that.
Same
She's
here.
not a flower person.
Same here.
And sometimes she appreciates a gift card at some places where she likes to buy clothes.
Yeah.
But I've done that enough times, and I hate to redo it again. So you wouldn't think it would be difficult after so many years. I know her very well. It's just I'm surprised at how difficult it is to come up with something. And if I find our callers, especially of the female persuasion, give me any advice, I would certainly.
A brand new weed eater would do good.
Yes, like you don't buy your wife a gift like a new vacuum cleaner.
A brand new weed eater. Listen, I've done pretty good lately with gifts, but over the years I've had some big failures.
Yeah, I think one time I heard Mean Joe say one day, that wasn't about a gift, but he said some of the things you don't do with your wife, and he said one of them is never ask your wife what's for dinner when she's mowing the lawn. Yeah. I thought that was hilarious.
Yeah, don't ask her what's for dinner when she's mowing.
But anyway, I'll go. I mean, it's just hard. I have a few things in mind, but they don't strike me as ideal. But we are going out to dinner. We're going to go all the way down. We're going to go. We like this place in here in town, the restaurant on the square.
Oh yeah.
But
yeah.
well, we're going to go down to Huntsville to a place down there and eat. Because we're going there because she wants to walk around the place where it's located.
The Bridge Street.
Yeah. I think it's called Connors or something. We're gonna go
Oh,
there.
Connors is very good.
It is. I often say my new standard for ribeye is right here, the 1819 place.
It's very good too. Very good. By the way, if you're going to Connors, make sure you order the voodoo shrimp.
Okay. I'm not a big seafood person, but she is. So.
The voodoo shrimp is.
And she does it.
Very
she
good.
Likes to go to those places. So we'll do something. But 38 years. A lot of people I deal with in the practice. I often say I have a record of people how long they've been married in my people I've dealt with in my practice. And there was one, I'd like to say it was 70 years, but it was just about 3 months short. So we can call it 70 years of marriage.
Wow.
That is impressive.
That is very impressive. That's very impressive.
And it's in a society where many people break up, don't stick it out and stuff like that. And I wouldn't have it any other way. I never did much divorce work, but it's just sad when you deal with people that are breaking up. It can't be a good time in their lives, it just can't. And it has a long-lasting effect. A lot of people come out of it, and a lot of people never do, but anyway, I'm happy. I've made 38 good years.
Well, congratulations.
Yeah, well, thank you.
Yeah, to you and your wife.
When's yours?
We just had one.
How many?
46.
Oh, wow.
But now I'm married very young.
Well, I can't get to 46 until I go through 38.
Yes, right.
I've got to get there.
You got to get there. Yeah, but Teresa and I married very young, so been married most of my life now by far.
Well, that's for sure. So I think I told you. Well, let me go over what's coming up. Of course, we've got a seminar coming up now. It's less than a month out.
That's right.
It's about 3 weeks out. It's going to be here at the WLX in the back, which you call the Country Cafe, which is not a cafe, and there's no sign. So
right.
I hate to say at the Country Cafe because people get lost. But it's here at the radio station in the back on September the 20th, which is a Saturday. And we're pretty much doing mostly Saturday seminars these days, and that's by popular demand. We do some on the weeknights, but folks have trouble getting there because life just gets in the way. By the time it's at 6 o'clock on Thursday sometimes, and they get home, dinner has to be served, kids have to be fed. It's just not convenient. So we started doing Saturdays, and we do a lot of them. So we get good attendance. So it's 10 o'clock on Saturday, the 20th of September. We call it Will's Trust in the Nursing Home. And that's what we're going to talk about. And if you haven't been to one, you might want to consider it. We get great reviews on our seminars. So a lot of information.
It's very popular.
A lot of information. So be prepared for a lot of information. Don't feel like you got to take notes on everything. Some people do, but just kind of sit and let it flow. It all sinks in. It's just it might be a lot of it would be new to you as well.
Sure.
If you listen to me on this thing or some of the other radio shows I do, you may be getting exposed to it for a second time, and then it really starts to sink in. So there's no rocket science about it. It's just when something's brand new,
right?
It's kind of, your brain kind of resists it a little bit just because it's something completely different.
Yeah,
and that's usually the hurdle. But you certainly can sign up for that. We like to keep an RSVP list just for head count. So you can call my office at Pierchoski Estate Law, Pierchoski Elder Law at 931-363-7222, and just tell us you're coming. That'd be great. We got plenty of room here, so don't have to worry about going to capacity.
Now that's on the 13th?
20th. September 20th.
The 20th. I don't know why I was thinking that.
I think that's a Saturday too.
It is, but that's the following Saturday, the 20th. Yes, so very good.
Well, again, we had several calls last week, so I want to go over that. This is a call-in show. Let's give them the number.
Yes, 766-9393. If you want to talk to Stan this morning, we do invite your phone calls while we are live here on WDXE.
Yeah.
And the number again is, of course, 931-766-9393 if you want to talk to Stan while
last couple of Fridays, we had some pretty good calls.
Yeah, we did.
And so give us a topic matter. But I was going to start off with a topic matter. I was thinking of you when this came around because it's real estate related.
Oh, okay.
But I mean, not real estate related in what you do, but it was the subject matter is a piece of real estate.
Sure.
And it's kind of a situation of something that could have gone really wrong, but didn't because we found it. You know what I mean?
Yeah.
So it had
Avoided a
it was
catastrophe.
It was a
maybe.
recipe for disaster, but I think we've, the Titanic missed the iceberg.
Yeah, good.
So, and here's the way it worked out. Actually, I think it was somebody from the last seminar. We had who wants to discuss, see if they want to engage in a plan, and we got together and met. It's called a family vision meeting. I have, and and it's like a 2-hour meeting, and that's something that I offer at no cost to folks who do attend my seminar. It's an incentive. Normally I tell people right now that if you try to get 2 hours of my time and just coming in off the street cold, you'll never make it past the girls in the front office.
Well, your time is booked.
Well, you won't get it without paying for it. But what I do, if you come to my seminar and get self-educated on some of the basics and fundamentals and the options, and then if you want to schedule this family vision meeting, I offer that at no cost. And it's typically an hour and a half, or sometimes 2 hours, but it's up to 2 hours of my time that I offer, which I don't do much hourly stuff. Sometimes when people want me to review a trust that I didn't write, I can think of no other way than an hourly fee.
Yeah.
And my hourly fee is $350. So
Okay.
it's a pretty good incentive. And it's not the kind of thing, if at the end of the 2 hours you decide you want to do a trust plan, that's great. If you decide you don't, that's okay too. I offer the time freely. And the reason I do that, it works great for both the clients that come to see me and for me, because if we talk about a lot of things at these seminars, a lot of different options.
Yeah.
And people, when they schedule these meetings, when they come to see me, they're now starting to lean towards one of them, and maybe want to ask some more questions about that. But we're kind of honing in on what got their attention of the several things that I talked about.
Right.
And if that's the case, we can spend those 2 hours. It makes it so much more meaningful, because now we're going to hit the ground running where you're kind of feeling like you want to go, like whether you're going to do the asset protection trust or the revocable living trust, how we can leave property to the kids, stuff like that, and we can hone in on that. We're not asking and answering fundamental questions like what's the difference between a will and a trust, and what about this? That's the stuff we talk about at the seminar. So we get past that, and we can spend this time. It's so much more meaningful. And so that is, or productive, and so that it works very good. It works for the folks that come in. It works for my office, because we just can cut right to the chase and get down on the family dynamics and hone in on the perfect fit. So
Sure.
That's why I offer the time, because it's a benefit to me. I mean, it's like I have some people say no lawyer's going to give up 2 hours of his time at no cost. And
Yeah.
well, it's not that I guess I am, but I offer it as an incentive, because I feel like this area is so procrastinated. So many folks come and do this say, we've been thinking about this for years.
Yes.
Talking about this for a long time.
Yes.
And don't feel bad if you're in that boat, because you're in good company. We all do it. And so that's one reason. The other reason is it's beneficial to me. I mean, we can get right to it. We don't have to go over the fundamentals, because you've taken the time on a Saturday morning to come and pre-educate yourself on this. And so that's how I reward it. So.
Yeah.
And I don't mind it a bit. I just don't mind it. For the same reason I give the seminars at no cost and stick around and answer questions.
Right.
How many times have I said, you cannot make a decision about this or really anything unless you're informed of the options.
Right.
I mean, which is why I think people procrastinate. They think, well, will's the only thing I can do. And so they hem and haw and don't do it because but once you know other options and one sounds good to you and it sounds like it's right down your alley, fits your family dynamics, then it's easy to pull the trigger. Procrastination is kind of out of the picture at that point, because you know and understand your different choices.
Yeah.
So anyway, that's my philosophy. I think it works. So, but anyway,
absolutely.
Get into this story. Folks came to me, and it was an individual, and in other words, he was not married. And he had gotten divorced some 30 years ago. Long time.
Oh, wow.
Anyway, so they decided they wanted to do a trust plan, and we're going over some of the specifics. And, one of the things we always put in the plans that we have is the real estate. Because that's big ticket items we like to protect. It was actually one of the asset protection trusts we do. And we want to protect that property from creditors, that sort of thing, from long-term care, things like that. So we move it into this asset protection trust, and we do that by retitling it. Like if you got a piece of property, belongs to Jeff and Teresa Hood, we would retitle it to Jeff and Teresa Hood, the trustees of the Hood Trust.
Yes.
That's in short words.
Right.
And so, and that puts it in the trust, right? So I'm looking into that, and they brought a copy of the deed, and I'm looking at it, and I noticed that the deed was still titled to him and his wife. So he got John Doe, and I looked at the deed and it said John Doe, and Jane Doe. Edux means
Yeah.
Latin for and wife.
Yeah.
And I said, okay, then I'd forgotten he told me he was divorced, and I asked him, can you give me Jane Doe's date of birth? Because we usually make reference to that in the deed so that we can show that you're the only, you have right of survivorship and you're the only one that needs to sign the conveyance to the trust instead of both of you.
Uh-huh.
He said, it wasn't, the marriage didn't end by death, it ended by divorce. And I said, oh, that's right, you did say that early in the meeting.
Yeah.
I said, well, why is her name on his deed? And the deed was from like 1980.
Yeah.
And I said, when did you get divorced? Around somewhere in the early 90s or something like that. And I thought, why is her name on it? So my wheels started spinning, and I thought, he said, well, we settled with that property with the divorce and all that. So I had Alex, my assistant, I asked her to pull up the tax cards.
Yeah.
We looked at those, and they had the name on it. And so then I told her to walk across the street and get a copy of the deed for me while I was during the meeting. And get the deed, and it comes back to me, and sure enough, it's the latest deed in time. There was not, I told her to check when she goes over, make sure there's not a deed before, after this one that we're missing.
Yeah.
And there wasn't. So I'm getting perplexed, and I said, well, surely the guy just got resolved in the divorce. And he said, well, I thought it did. And he said, I said, I know her name's been on there, but I always thought it was belonged to me.
Yeah.
And so I got started, so anyway, I started thinking, well, somebody dropped the ball on this. So maybe one of the divorce attorneys. Now, I'm not looking to blame anybody. I'm trying to find out what's going on.
Sure,
And so I thought, well, surely, gosh, when you have a divorce, you have an MDA, marital dissolution agreement, which is the final order that says, you got to do this, you got to do this. Here's what you get, your husband. Here's what you get, wife.
Right.
And it lays all. And if you got minor children, you're dealing with that.
Right.
Anyway, that usually deals with property. And so I asked Alex to go over there, and she was over there for a little while because in the Chancery Court they had to go to the archives because this was dated 90 or 91 or something like that.
Yeah.
And so she comes back with the MDA, and she had already looked through it for me and had highlighted a paragraph in there that talked about the property. And here the court order was for him to pay her some money, and at when she received that money, she was to sign the quitclaim deed.
Yes.
And there was some other stuff that was in there, but that was essentially the thing. And I asked him, did you pay that money? He said, yeah, he did. But he said, best I can remember, I do. And it wasn't a lot of money, but I'm just saying it was. So, and I thought, well, I don't understand why your attorney wasn't all over them for not doing what, it's kind of thing, you will sign the deed, but not until you give me the money, because the money was for their, we're talking about in the 90s, so the property may have been worth $30,000-$40,000.
Right.
So it wasn't that much money, but they're buying the person out, the kind of thing.
Yeah, exactly.
And so, and he said, as far as I remember, I gave it. I don't remember the amount, but I remember we did this. And so I didn't want to get into the specifics. We're not looking to hold anybody in contempt or anything like that. But here's the bottom line. I said, here's what this never got done. This quitclaim was never done to you. She is still an owner on this piece of property. So Jane Doe owns this property. Now you're not husband and wife because even though it says husband and wife, if you're not husband and wife, that terminates the right of survivorship.
Yeah.
And now, without right of survivorship, then it's a tenants in common with a 1/2 undivided interest. And so I asked, how many children do you have? He said, well, we got these 2 children. I said, did she have any children, like, of a prior marriage? He said, yeah, she had 1. I said, do you know if she has a will or not? So I'm pretty sure she does not, because they were still kind of on speaking terms, I think.
Yeah.
And I said, well, here's what can happen, And he seemed to assure me that there would be no problem whatsoever for her to sign that. And so we're sort of, we moved into that and things worked out pretty good. But I said, here's the situation we have. If she passes away and she doesn't have a will, we talk about if you don't have a will, everything goes by the laws of intestate succession.
That's right.
Which is where the state of Tennessee has already decided. And what it's going to do, it's going to look to see if you have a surviving spouse, and she didn't, and certainly it wasn't him because they were divorced, and she was not remarried. And if you don't have a surviving spouse, it's going to look to your children. And she's got 3.
Yeah.
2 with him and 1 with somebody else.
Right.
And that was not what anybody really wanted, apparently. And I said, that's what's going to happen if we don't fix this,
Yeah.
And I said, you can still do this trust, but you can only put in the part you own. You can't put in in other words, you now own it with, John Doe now owns it with Jane Doe.
Yeah.
1/2 undivided interest. You can put your interest into the trust, but now your trust is going to own basically your half with Jane.
Yes.
And we do that often with properties, that's the way they want to do. You know, they want property with their brothers and sisters. They put their share into it. But this is something that was a mistake. I mean, this should have been done like 30 years ago.
So it was overlooked. The quitclaim was overlooked.
Well, it didn't get done. If it didn't get done, the property didn't transfer. You can say, well, it should have been done. It could have been done. It just never was done. I'm not sure how that would pan out if it had to go to court, and the court had to decide whether or not the MDA. You know, my thought is this: the MDA is ordering it. It just never got done, so that might be enough to carry the day that the property belongs to him.
Right.
I don't know. I've never really seen it. I would rather not go on that because the deed is the indicia of ownership.
Yeah.
If you own something, it's in the deed, and that's all there is to it. And it's not. It wasn't. So anyway, so you know, we'll see how that turns out, and I'm pretty optimistic everything will be okay. But you know, that's kind of had a recipe for a real problem.
Yeah.
And it was a real surprise to them.
Yeah, I'm sure. And you know, there's probably countless people out there that assume that things are a certain way. And then, and I've run across this many times, and they find out that it's not that way. It's another way. And it happens a lot. It happens a lot.
What surprises me is when people get divorced, it's usually pretty adversarial. I mean, sometimes you get divorces where, I call them friendly divorces, where most people can agree and they just walk away. There's a fair amount of those, but a lot of them are ugly, adversarial. Yeah. And, you know, when you had something like that, it was a quid quo pro. In other words, you had to buy the person out to get the deed.
Yeah.
It surprises me that wasn't brought up and done. Now, you know, he had a lawyer, she had a lawyer. I think his lawyer dropped the ball on that because, you know, back then if somebody just refused to do it, now I'm not saying they refused to do it. I think they just didn't.
It just didn't happen.
Nobody followed up.
Yeah.
But if you don't do that, that's a court order that says to do it. That's contempt of court, and that has a lot of teeth to it.
Yeah.
And that's how you get it done. That the threat of contempt of court, and that's why it's in the court orders. The court is ordering that, and you know, if you don't follow a court order, they like tend to make an example of you so that people don't think it's okay to just not do what the court orders. And so that could have been a problem. But I guess, you know, it's the kind of thing if they had just overlooked it, if somebody would have followed up on it, they said, oh, I'm sorry, I forgot I didn't do that. I don't have a quick, because in my opinion, who would draft that quick claim deed? It would have been the person getting the property's attorney. All ready to sign, maybe undated because we know we're going to do one. It's in the order. We just don't know when the money's going to get paid. I think it said money had to be paid within 30 or 60 days or 90, something like that.
Yeah.
Some period of time. So we know a deed's coming. I had one all ready to go that wasn't dated. And then when they said, hey, we did this transaction, now we want the deed, you know, that sort of thing. And typically, if it's really adversarial, you would say, okay, go get a cashier's check, bring it to my office.
Yes.
Everybody meet in my office. I say, okay, here's the check, here's the deed. I'm going to hand you the check, you sign the deed. And that's, you know what I mean, that sort of thing.
Yeah, and then somebody's got to be responsible to record it.
Well, I mean, but at least the deed is in his name now. And then you just take it over to the courthouse and record it. But still, it's, anyway, it was like a little Sherlock Holmes puzzle for me. I had to kind of ferret it out. And I thought, I can't hardly believe it got missed in a divorce, but it would have only had to have been transferred because of the divorce.
Right.
And the decree should say that. I would have been really shocked if the MDA did not address the property. Because that would have been a real problem. At least now we know what the intent, what the court was ordering. So I don't think anybody's going to have any problem doing what the court ordered because, you know, it's still something that can be brought up. We're definitely outside the 60 days.
You know, that to me, that's just, you know, that kind of work is interesting. You know, it gets you engaged in the process. You know?
I told him, I said, that's almost fun in a way. If it wasn't so much at risk, it's kind of fun on my end to ferret it out.
But it's a problem you've solved. It's
we brought it to light. Now we can fix it.
You solved the problem. That's right.
Well, and the same thing at his death. You know, he has some children he wants to leave it to, and they're not going to get it all, which is what he thinks they're going to get.
Yeah.
If we don't fix it. So.
Yeah.
So it's and stuff happens. That's definitely the exception to the rule. You know, because stuff happens, but
people have assumptions of the way things happen. I'm not. It's been a while back, but we were going to work on what was thought to be an estate.
No, okay.
Come to find out, this was a piece of real estate, and in the family's head, it was their father's estate. But many years ago, he deeded the property to his children. So the property was not in the estate at all, but in their head it was.
Yeah.
And so we had to kind of say, look, honestly, this is not a part of your father's estate anymore because
He doesn't have it to give
he
you.
doesn't. It's not his to give.
Yeah.
You guys own it, and but in their family dynamic, they wanted to treat it as an estate, and divide the property up, and which is what their intent was. But still, it was hard to get through their head that we're not doing an estate.
Yeah, it's a bad time to get a surprise.
Yeah. So it's funny.
Remind me to tell you a real estate story that involves.
Yeah. Well, one of our regulars wants to talk
Okay.
with us,
All right.
and no telling what we may have today. Good morning.
Alabama does. And when somebody comes here, they're accepted. But also Tennessee, in my understanding, doesn't have no fault divorce. They have a list of reasons for divorce. And I thought that alone might be an issue. People coming in that have wills written in another state where it complicated a lawyer's life if they didn't really have all the information. If you'll comment on that in just a minute. And a second thing is, I have read about sheltering income, just like you do your real estate. Is that in the same trust, or it's called a qualified income trust? Is that the same trust as you're talking about sheltering your real estate? And a review of that, I'm still confused.
All right, thank you. Very good. Well,
I was gonna make notes, but none of these pens work.
we got a lot of pens that don't work.
So I have to go by memory. Now, the first thing, I get the QIT, and we'll talk about that, okay?
Okay.
Last. The first thing had three things in there. It had wills from another state. It
Yes.
had common law marriage, and it had grounds for divorce, if I'm ever right.
Yes.
Okay. So let's take them one at a time. A will from another state. Now, I think she was referring to somebody else that said that she thought was in conflict, that somebody was told, if you move here from another state, you need to get a new will governed under this state's law.
Yeah.
So you come here from, I don't know, Colorado, and you have a Colorado will. Do you need, or any other state, you come here from one of the other 49 states, and you come to Tennessee. You guys were talking about this earlier about coming to Lawrenceburg.
Yeah.
If you come to Tennessee and you have an out-of-state will, do you need to do a new will? In my opinion, and I think my opinion is, I can back it up with legalities. The answer is no, not just because you came from one state to another. That's not, that reason of and by itself does not require a new will. And the reason is, all states under the Constitution, Article 1, the states give each other full faith and credit is the term, the full faith and credit clause, which means, when you travel from state to state, you don't like need papers like you used to in some of these older countries.
Right.
The states are all individual states, free to pursue their individual pursuits, but they are part of our union, right? So each state gives all the other states full faith and credit, which means if you pass away in Tennessee and you got a Colorado will, Tennessee will recognize the Colorado law that governs that will, and you can probate it here.
Yeah.
It was domesticating it. We domesticated it by dealing with Tennessee, but it still is governed by Colorado. In other words, we don't apply Tennessee law to it.
Okay,
We apply
that makes sense.
we apply Colorado law to it here in Tennessee.
That makes sense.
Now, sometimes that can be a little bit cumbersome because it requires Colorado law, right?
Yeah.
But so is it? You don't have to get a new will.
Right.
It's not a bad idea, and a lot of people do because when they come here and they say, "Hey, I got this Colorado will, I want to change to Tennessee," but it's 20 years old, and there's a lot of things I want to change.
Sure.
Now that's a reason to change it. And if you're going to change it, then let's make it the situs of where you are, which is Tennessee.
Right.
So it
That makes sense.
in my opinion, you do not have to.
Okay.
I have when I used to do probate, I've probated out-of-state wills many times.
Yeah, okay.
That's not that big a deal, it's easy to do.
Yeah.
And so we've done that, same thing with trust.
So if you're not changing the will content itself, then the state which it was originated governs.
Wills are governed by state law.
Yeah,
And so
okay.
and same thing with trust, governed by state law.
Yeah.
So I've administered out-of-state trusts before.
Interesting.
So there's that. What I said, second one was common law marriage. Okay, common law marriage has really nothing to do with the will, but I guess it could. But
Yeah.
a common law marriage is when you, I'm not sure what the definition would be, other get married in the eyes of God and not by the power of the state. Because a state says a state can say state law presides over marriage.
Okay.
Now, it's a statutory marriage, okay, where you ask the state's permission to get married.
Okay.
Here's what it was. That's what the marriage license is.
Right.
And when you get in front of the preacher, and the preacher says, "By the power vested in me by the state of Tennessee,"
Right.
that is a state marriage. Okay.
Okay.
Or statutory marriage.
Right.
Well, when you have a statutory marriage, there's also something that goes with that called a statutory divorce. In other words, if you have a statutory marriage and you ever want to get a divorce, you get a statutory divorce, and there's laws that govern the divorce process.
Yes.
Okay. If you get a common law marriage, you've not entered into that. You and another person decided, you need your divinity in the eyes of God, you're going to be married. And which is where marriage came from in the first place.
Right, exactly.
State of Tennessee did not invent marriage, okay?
That's right.
God invented that himself, and so you can get married that way.
Mm-hmm.
Now, they say some states don't recognize it. That doesn't, people tend to think, well, at least I think some people tend to think that means, like, if you have let's say Tennessee doesn't recognize it, because they don't.
Okay.
So it sort of makes the picture in your mind that if my wife and I get married in the eyes of God, but without a Tennessee marriage license, that if they find out about it, they're going to make us move out of the house and get away from each other.
No.
I mean, they don't do anything about it. When it's not recognized, I'm going to have to ask you to think a little bit like an attorney would think. Okay. When you have a statutory marriage, and there are what we call statutory remedies for that, especially in divorce, which means in a statutory divorce, you can have the custody of children. Okay. You have the division of property.
Yeah.
You have the third thing, the grounds for default. I mean the grounds for termination of the marriage.
Uh-huh.
These are all statutory remedies. Alimony, child support, those are statutory remedies. And so when the courts say they don't recognize it, where it could come up, an example I'm thinking of is an actual court case, where it could come up is people are common law married, and they're in a state where it doesn't recognize it, like Tennessee, and they decide they're going to split up. Okay, now they're going to split up. Let's say the dad's a deadbeat dad, and mom goes to court, wants to petition the court, and she wants to get child support for the children and alimony. Okay. Well, the court's not going to give a statutory remedy to a non-statutory marriage because they say they don't recognize it because those remedies are only available for a state statutory marriage.
Okay.
Now, the famous case was many years ago with Lee Marvin. Remember the actor Lee Marvin?
I do.
And his partner, that gal, her name escapes me, but they went through this horrific court case, and they labeled it the term palimony because it was over support.
I do remember this.
And they called it palimony because they weren't married. And now that kind of created this concept that you can't call it alimony because that's a statutory remedy.
Yeah.
But it's you can't call it spouse either because they're not really spouses, but they're husband and wife. But it's support for one of either the husband or the wife.
Right.
So and now. Tennessee says they don't recognize common law marriage, but they do say, as I think the caller mentioned, they do say they will recognize it if people come from a place that did recognize it, which means in Alabama they do recognize it. You can have a common law marriage in Alabama, and if you move here to Tennessee and now you have a common law marriage, Tennessee will recognize that because the state you came from. Again, this is part of this full faith and credit concept of the Constitution. They'll recognize that. I don't know which states do what of all 50. Never really had much reason to look into it.
Right.
I don't know if any of them that don't recognize common law also say, I don't recognize it if you come here with it, you know what I mean, or come
Yeah.
from a place that does. I think that would violate the full faith and credit, but that's how that works.
Okay.
You know, in other words, you gotta think in terms of statutory.
Yeah, yeah.
You know, I used to have,
Well-
oh, go on.
Well, one part of her question was, and I was gonna, and you may not be through with that, but, the no-fault divorce one.
Oh, okay, yeah, now, there is fault for divorce in Tennessee. There's
Yes.
a whole list of things in the statute.
Okay.
I mean, it's abandonment, it's infidelity, I don't remember them all. There's a lot of attorneys that do family law and divorce law that would know them much better.
But Tennessee doesn't have a no-fault. Is that
No,
what
I mean,
what she was asking?
No, we don't, yes, we do, okay,
Okay.
there are listed grounds for default.
Okay,
But I never did much divorce work, but
Okay.
when I did, I mean, I had some familiarity with it, and maybe not the best person to describe it, but I got a good understanding of it. And that is, there are grounds for default, but I'm gonna bet you 95% or more of divorces go under a catch-all. It's not exactly fault, it's called irreconcilable differences.
Yeah,
And it has its
okay.
own little procedure. Basically, it's like irreconcilable differences, but it means a difference that's irreconcilable can be anything.
Yeah.
I mean, you could not agree on that the saucers go in this cabinet and the glasses go in this one. And you don't even have to state the difference.
so,
You just have to say there are irreconcilable differences.
Yeah,
So that's kind of a no fault, but it's
Yeah.
kind of like, it's not exactly no fault, but it's just saying, whatever the fault is, we're not gonna address it as fault.
yeah,
But you know, if you have somebody, they say, you know, infidelity,
yeah,
that's a grounds for default. And certain things are only available if you're suing for default under grounds.
yeah. Okay.
Yeah.
Interesting.
So 99%, I mean, it may, I don't know about 99, but most of them are irreconcilable. Because it's very expensive to get divorced on grounds. I mean, you can get into a jury trial. I
Yeah,
don't know that I've ever seen a jury trial for divorce. I mean, you know, some of the high profile ones, yes, but I'm just saying locally, I mean, it's exorbitantly expensive, I would think. Where technically most people, no matter how adversarial they are, they just sit down and just decide, you get this, you get that, here's how we're gonna divide the kids if you have minors involved.
Yeah.
And just end up walking away. Now, some people can never get there. I'm sure there are trials for divorce, but it's in my opinion, it's rare, but a divorce attorney might be a little more fountain of knowledge on that
Sure.
than me, but,
Sure.
so there is something, I guess we could call it no fault, divorce, because we're not gonna put any time, energy, and effort on the fault.
okay, yeah, okay,
But in other words, it's kind of like a shared,
Irreconcilable differences.
it's like a shared fault. We can't agree on things.
yeah,
So we both can't agree, so the fault's with both people. But we're not even gonna talk about what we can't agree on. That doesn't even have to be in the petition.
that's amazing.
Yeah.
Yeah,
No.
okay.
I mean, there's a need for it, and that's why it exists.
Yeah.
That's how most of the marriages go, so.
Absolutely.
Now, the last thing she mentioned was a QIT, and I forget what she said about it, but it doesn't matter, because I'm gonna tell you what a QIT is.
Okay.
QIT stands for Qualified Income Trust. It's often referred to as a Miller Trust, and it gets its name Miller Trust from a lawsuit many years ago where the head of the Department of TennCare was named Miller. So it's like, say, it's John Doe versus Miller, Commissioner of Bureau of TennCare, something like that. And so it gets its name Miller Trust. It's a very specific trust, and it's the kind of trust, you know, when we deal with long-term care, you have an income cap. In other words, if you're over $2,901, and that's what it is for 2025,
Okay.
you're over-resourced on the income category.
Yes.
But that's not a deal breaker. The law says if you get $2,902 or $1 over, you're not eligible. That's clear. However, it's not a real deal breaker because what we can do, and what the law allows us to do, is open up a QIT. It's just a 3 or 4 page document with trust, mostly with the bank.
Yes.
It's called a qualified income trust, and they will, because when you're in long-term care, all your income goes to the cost of care.
Yes.
Minus the things we can deduct, which is Medicare and payments and stuff like that. But
Right.
anyway, basic rule of thumb is all your income goes to cost of care. So if you're over the amount, we can open up a QIT, and whatever's over the amount, put into the QIT, because the QIT is an irrevocable trust that's irrevocable and unassignable, and says the only place this money can go is to the cost of care.
Yeah.
So let's say you got, it's 2,900, it's 2,901, which, I don't
Yeah.
really get this stupid number, but they don't wanna round it off.
Yeah.
$2,900, let's say you got $3,000 worth of income.
Yeah.
Okay, you got
Yeah.
$100 over. So every month you pay $2,900 of your income to the facility where you're in long-term care, and every month you pay the $100 from the QIT to the facility, because they're gonna get it all. This is something us estate planning attorneys have questioned for years, is it's all going to the same place. Why do we have to bifurcate it, put it different places, write 2 different checks every month, and it's all going there anyway? And
Yeah.
that's just the rule, because if it's more than that number, you're over-resourced. If you take the overage and put it in the trust, which means it's gonna go to the cost of care, we're gonna consider that process not over-resourced. So it's kinda, quasi-futile, but I get the concept, and pick your battles. You know, they let us do it if we do
Yeah.
it that way, so we'll do it that way. But that's what a QI, that's its purpose. So it doesn't have anything to do with the other stuff, it doesn't have anything to do with the common law marriage or
No.
the other stuff, so.
No, but it solves the problem, again.
It solves the problem, that's right.
Yeah.
And that came up many years ago, and that's really a kind of a banking kind of thing. So you got this trust, the person that's working, you know, either the person in care or the person, power of attorney for the person in care, is the trustee of that QIT.
Right.
And the money in there can only go one place, and that's the cost of your care.
Right.
And
Right.
so, his idea is to catch what goes over the cap. Now, the cap changes every year, and so the amount that goes over, the income cap will change every year too, but.
Okay.
So, anyway, that's what it's for. We use that a lot. We have a QAT a lot of times, especially when we do these Medicaid compliant annuities, because what we're doing
Yeah.
is taking a big lump sum of money and turning it into a stream of income, and that almost always pushes us over the cap. Because the income cap is
Yeah.
a little on the low side, 2,900. So,
Yeah, the annuity you mentioned, I was gonna ask you about that, because we've talked about it before, but it's been a while, and how that works and why we have to have that.
well, we don't have to have it, but it is a strategy we can do if you're over-resourced with something. Here's a good example. If you have an IRA,
Yes,
I don't know, let's say you got $200,000, $100,000 in an IRA.
okay,
You cannot put that in any trust. You can't put it in an asset protection trust, you can't put it in a revocable living trust. You can't put it in a trust because you don't own the $100,000. A lot of people get mad at me when I say that. They say, bull, I own that, that's my money. Well, I get it, but let me finish the story. You don't own the $100,000. What you own is the stream of income that this thing is designed to do you can start taking distributions at 59 and a half. You have to take them at 73.
Okay.
At 73, you gotta take the required minimums, right? But you can start taking distributions anytime after 59 and a half. Now, what you own is that stream of income, those distributions, okay? Now, you do have some ownership in it, because if you pass away, you can leave what's left of it to your heirs, right?
okay,
So, but if you go into long-term care, in 2019, Tennessee, along with several other states, 20 some other states, modified the rules on these, saying that, it used to be if the IRA was not in payout status, it was considered countable. Remember, we talked about countable assets when trying to be eligible for care. But once it was in payout status, it was considered a non-countable asset. So it kind of had its own little protection to some extent. And it was also different between the spouses, if you're a married couple. Well, in 2019, they changed that. It's countable for both spouses always. And in other words, it's just countable, and that's all there's to it.
right,
And so that's a problem. That's one very favorable change for people that have to end up in care. But there's a way to deal with that. So what we do is we don't put it into a trust, because, let me back up. I said you can't put it in any trust. Well, you can't put it in any trust as an IRA or a 401k or as a tax-deferred account. But you can put it in the trust, but what you have to do is cash it out, pay the tax on it, and put it in the trust as a lump sum of money. But now it's not an IRA or a 401k anymore, it's just $100,000, right? So you can put it in, but that's not always the best thing to do. So what we advise, and what we have done many times, is let it pay out in your retirement years, because that's what it's designed to do, right? That's why we put the money into it. That's what IRA stands for, retirement account. And you put the money in there, and you start taking distributions in your retirement years as part of your income.
right,
Now, if long-term care comes into the picture, and we're talking about, you have to go into care, now's the time to fix it. What we can do with that is we can cash it out. Because here's the thing, if all your income's gonna go to care, and you're getting income from your IRA, we can control, as soon as you get it, it's gonna go off to the cost of care, and we can control that. So what we do is we just say, okay, we're gonna cash it out. But
Yeah.
once you're over 59 and a half, you can cash it out anytime you want.
right,
So I wanna cash it out. Now, the first thing that comes to mind is, yeah, but now I owe the tax on it. Well, not just yet. if we can roll it over into a similar instrument, similar with same tax status, within 60 days, we don't have to pay the tax.
Sure.
And now what we're gonna roll it over into is called a Medicaid compliant spousal annuity, typically spousal. We can do it with single people, but let me use the spousal annuity. And it's a special kind of annuity. It's a single premium immediate annuity. I mean, you pay one premium, you don't pay monthly. You pay one big fat premium, which is the money you just cashed out, essentially. And it starts paying back immediately typically to the spouse, because if it pays to you, you've got too much resource. It can't. That's the whole idea what we're doing. We're trying to get it away from you, keep it in the family, so we'll go to the spouse. And what we've done when we do that, so we get a Medicaid compliant annuity, and the annuitant is the spouse. Now, what we've done is we've taken accountable resource. Remember I said in 2019, they said your IRA is accountable. What does that mean?
Right.
It means if you go into long-term care, you are going to be expected to cash that out and use the money for the cost of care. Because they're going to tell you, as long as you have this $100,000, you are over-resourced. Right?
Right.
So, what we're going to do is we're going to take a countable resource and turn it into a non-countable stream of income. That's not even yours.
Right.
It's somebody else's.
Okay.
And we can do that.
That's interesting.
As long as it's Medicaid compliant. So a Medicaid compliant annuity, what does Medicaid compliant mean? There's a handful of requirements, but the couple of biggies are, one, it has to be actuarially sound. So if I'm doing that, I have to go to the actuarial tables and look up my age under male, and the government now knows how long I'm going to live, or at least actuarially, right?
Sure.
And it says 10 years. The annuity cannot exceed my actuarial lifetime.
Okay.
So you can't be 95 years old and do a 40-year annuity. Is a good idea.
Yeah.
So this, it says, okay, you can do this annuity, you just can't exceed this 10 years. You can't pay out longer than that.
Sure.
That's usually never a problem. I've run into that once, because the patient in long-term care was like 96 or 97, and the annuity had him down for like 30 months of life left. I mean, the tables are the tables. It doesn't mean that's how long you're going to live.
Yeah.
It's actuarial speaking.
Sure.
So that's usually never a problem. The other thing is, the other compliant issue is it's got to be irrevocable and unassignable, which means once you do it, you can't undo it. And there's a reason for that. Let's suppose you're trying to get eligible for TennCare. And so you take this annuity, you take this IRA, you cash it out, you turn it into this annuity.
Right.
Now you're eligible for care, right? Because you don't have that $100,000 anymore. You get eligible, and after you get approved for eligibility, now you go and cash that out, and now you have the $100,000. It's come back to you.
Okay.
TennCare, you always got to think like TennCare in that how are you going to screw us out of the money? And so they'll say, we'll let you do this, but it's got to be irrevocable and unassignable, so that it can never come back to you, the person trying to get benefits.
Okay.
Because with the benefits only are for people that are below these levels. Okay?
Sure.
And so that's the big thing, and it's not a big thing usually. Yeah. And there's a couple other things. The monthly payments have to be equal. You can't do a small amount and then a big balloon payment at the end, stuff like that. So it's usually easy to comply with. But that's what the Medicaid compliant annuity is. And that usually causes, and sometimes when we do that, it certainly causes the person we're giving it to have an increased income.
Very good. Qualified income trust, Miller Trust, and then the
common law marriage.
The common law
grounds
marriage.
for divorce.
And but what I was thinking about is the annuity.
Yeah, the annuity.
The annuity. We're learning all the way, man.
I was going to tell you. I said, remind me to tell you something about. Now it escapes me. My short-term memory. I only got 5 minutes left anyway, but it's not coming. Just as the call was coming in, I said, remind me to tell you something about. Oh, it's a real estate story. I can do it quick.
Yeah, do it.
Another real estate story. You were talking about in people's minds, they think they have this property or this estate,
sure.
and then they find out. I had an estate we were doing, and we had a fair amount of property, and I couldn't account for it all. And the other attorney representing the other person, because we were dealing with a state, but they each side hired an attorney because they wanted to work a divorce out in there too. But I don't want to complicate it with the divorce. But there was attorneys on both sides. Yeah. And I couldn't account for all the property. I'm talking to my guy, and I said, and so the people on the other side said, well, we got some people that do a lot of deed work, and they couldn't account for it either. We just couldn't figure out what happened to it. So I sit down with my guy, and I said, listen, we got this 4 acres or something like that over here. There's no record of it. We searched we did title searching. Yeah. We did all the things you do. Yeah. To when you deal with property, we couldn't find it.
Not
of course, my client was probably in his 80s, and I'll never forget this because he goes, oh, Oh, yeah, so I remember that. Said, that belonged to so-and-so, or something like that. I remember, yeah, back in something. He said, yeah, man, Daddy traded that 4 acres for a bull. I about fell off my chair. I mean, now, we do things now in 2025 with a little more dignity, a little more formality.
Yeah.
But when you think about it, back then, that probably was not, handshake and here's the bull.
Here's the bull.
Here, move your fence to include these 4 acres now.
Yeah.
But I mean, without
a simpler time. Yeah.
Without a record of it, it got in the way.
Kind of got lost.
But it was perfectly clear in his mind.
Yeah.
He had that because his daddy traded a bull for it. It belonged to his dad, and it came down to them. But there was just no record of it. I just got a kick out of that.
How about that?
And when you think about it, is there anything really wrong with that? I mean, it's definitely an agreement.
Yeah.
It was proper consideration, bull for land.
Yeah.
I mean, all the elements of a contract are there.
Yeah.
Intent. But it just kind of, the documentation of it just created some issues. 50 years later, it was.
Yeah, that's the kind of thing that can get lost and then
yeah.
it's just gone.
But that always makes me laugh.
Wow.
Anyway, it looks like we're coming up on the.
Yeah.
Up on the.
Just give your contact information and all that before we go.
We do this at Pierchoski Estate Law, Pierchoski Elder Law. You can give me a call. I'm right there on the southeast side of the square in Pulaski. 931-363-7222. That's 931-363-7222. Or you can, send me an email. It's Pierchoski State Law. .com, but if you can go to it's stan@pierchoskiestatelaw.com. But you can email me by going to my website, which is estateplanstan.com.
That's the best way.
And you get to the website. You can see my phone number there. You can see my email. If you want to send a question by email, you won't remember stan@pierchoskiestatelaw.com. So,
Estate Plan Stan is easy to remember. That's a good one. That phone number is 363-7222.
Want to come to the seminar? It's September the 20th. 10 o'clock in the morning, right here at the WLX radio station in the back, couple double doors toward the back of the building. Just come on in. We'll have some light refreshments. Call it Wills Trust in a Nursing Home. Yeah. That's what we're going to talk about. You'll hear some interesting things. I can always tell when I'm giving a seminar. I pretty much have everybody's attention.
Yeah.
Because it's stuff they haven't heard. And if you come to a estate planning seminar, you come to hear stuff like that.
Well, it's great information and great for your family and your future planning and your estate, no doubt. Appreciate you being in this morning, my friend.
We'll do it again next Friday.
Next Friday, we'll see you then.
Communications.
Right on the money.
Buddy.
I'm Therese Crowley, Fox News. President Trump revoking the